Well, you know I've said it before, but sovereign citizens are idiots. And we have yet additional proof in the Darrell Brooks trial. I'll have more on that in just a moment. As you may have seen in the Darrell Brooks trial, he makes numerous references to subject matter jurisdiction. Here are just a couple of them.
No.
Still has yet to be proven for the record. Is that a judicial determination that you don't have to answer that, Your Honor?
Mr. Brooks, I've already answered subject matter jurisdiction. You know that full well.
No, I don't.
The decision was entered last week.
I know nothing. It has yet to be proved. That's what I know.
Doesn't need to be proved.
It does.
Are these irrelevant comments?
We haven't addressed subject
All
matter
right, thank you.
jurisdiction yet at all
Everyone,
either?
please be seated. The jury will
we're not gonna
disregard the
address subject
statements
matter?
Mr. Brooks is making about subject matter jurisdiction. They are a misstatement of the law.
So as you can see, Mr. Brooks is clearly getting into a spat with the court about subject matter jurisdiction. Well, where does subject matter jurisdiction comes from? It comes from two places: the United States Constitution and the Constitution, in this case, of the state of Wisconsin. Well, what does the Constitution of the state of Wisconsin say about circuit court jurisdiction when he's being tried in the circuit court? Well, here is what it says. Except as otherwise provided by law, the circuit court shall have original jurisdiction in all matters civil and criminal within the state, and such appellate jurisdiction as the circuit as the legislature may prescribe by law. The circuit court may issue all writs necessary in aid of its jurisdiction. So essentially, the Constitution says that if you're going to be tried for a criminal offense, you have to be tried in the circuit court that has jurisdiction over that criminal offense, meaning the circuit court that covers the county where the offense occurred. In this case, that's Waukesha County, and the Waukesha County prosecutor is the prosecutorial entity that represents the state in this matter. Now, Darrell Brooks has access to the Constitution. They've given him the law books. He can get access to it anytime he wants. It's certainly available online. I'll post a link to it down in the description of this video. But courts also interpret the Constitution, and in the course of cases, they make statements about their own jurisdiction. And indeed, in Wisconsin, they have made numerous statements about their jurisdiction, one of which is that the circuit court's jurisdiction in criminal cases is plenary. Now, plenary is a word that is not often used in casual conversation, and if you go to Webster's online, you can look it up. And basically what it means is unqualified and absolute. In other words, it has absolute jurisdiction over all criminal matters that arise in that location, in that jurisdiction. All criminal matters that arise out of state law. Now, the United States Attorney and the Department of Justice would have jurisdiction over federal violations. But in terms of state law violations, and of course the Constitution says that police powers are reserved to the states, so the states have the right to police their own populations within the limits of the federal Constitution. So what's all this about subject matter jurisdiction and subject matter jurisdiction being proved? Well, somewhere along the line, someone convinced Darrell Brooks that he is a, quote, sovereign citizen. Now, what is a sovereign? A sovereign is essentially a king, someone who is, or who has been declared to be, or has declared to others to be, a person above the law, or the creator of the law that applies to him. You may have heard the phrase, the king can do no wrong. It's often used to justify sovereign immunity, which means the state can't be sued in some jurisdictions. I think it's a stupid concept, but at any rate, that's the law. And when you assert that you are a sovereign citizen, that you are necessarily above the law, what you invite is chaos, because I could assert that the next door neighbor that I don't like is not a human being, and I could go over and murder them and say, hey, I'm a sovereign. I determined that this was the law, and I killed him, and you can't prosecute me because I'm a sovereign. That is as stupid when I say it as it is when Darrell Brooks says it in court. The idea that subject matter jurisdiction needs to be proved is ridiculous because he wouldn't be in court if the court did not have jurisdiction. You don't have to prove subject matter jurisdiction. Does that mean you can't challenge subject matter jurisdiction? Absolutely, you can challenge subject matter jurisdiction, but you have to have a basis to challenge it. If the Waukesha Parade murders had occurred in Missouri, for example, the Wisconsin court would not have jurisdiction because that's not where the crime was committed, right? But because the crime occurred in Waukesha County, sorry to all the people from Wisconsin who are watching this because I'm not really well read in on a lot of these Native American names. But because the crime and the offense occurred in Waukesha County, that is where the court has jurisdiction. And the idea that it needs to be proved, as I said, is just ridiculous. So one of the things that is really funny about courts is when you go to law school and you become a lawyer and you work your way up to the point that you're appointed to a judge, you have authority to act on behalf of the state as a judge. And you don't like to see your authority challenged. Now, does that mean you can't tell a judge they're wrong? Absolutely, you can tell a judge they're wrong. Once, sometimes twice. But when the court makes the ruling, the court makes the ruling. You can put your objection on the record once, but you can't keep putting it on the record every time. All that does is it annoys the judge. A good friend of mine who was a Supreme Court judge once told me that you should never try to teach a pig to sing because it wastes your time and annoys the pig. Well, that can certainly apply in courts. You don't want to waste the court's time and annoy it. And when Mr. Brooks continues to say subject matter jurisdiction has not been proved, he's wrong. And the judge tells him he's wrong and he won't shut up, which is why he's been removed from the courtroom several times. This is all about him. In other words, this is an exercise in narcissism for him. And I feel badly for Mr. Brooks because it's very clear he has some kind of mental disease or defect that prevents him from recognizing when he is wrong. If you have followed any of this trial and you've seen the step-by-step way that the state has put together a case against Mr. Brooks, starting with the events of the day, starting with numerous witnesses, the police investigation, what they found, how he was caught, how he was arrested, and the statements that he gave to police, I think they've done a very good job of proving his guilt in this particular instance. The jury will still have to reach a verdict as to whether or not he is guilty of all these charges. But getting into the nitty-gritty of subject matter jurisdiction and making the same objection numerous times, and let's face it, objecting to being called Darrell Brooks when your name is Darrell Brooks, all that does is it annoys the jury, and it makes the jury angry, frankly. If I'm sitting on that jury, I'm thinking, what is this guy trying to prove? If he wasn't the person who was in that car, he should prove that he's not in that car. But proving that he's not Darrell Brooks or saying that he's not Darrell Brooks doesn't prove it. As somebody once said, saying it isn't so doesn't make it not so. Just the way saying it's so doesn't make it so. Saying that you're not Darrell Brooks doesn't make you not Darrell Brooks. And unfortunately, Mr. Brooks has not learned that lesson yet, and that is quite unfortunate for him. All he is doing is prolonging his misery. He is sitting there in court with a silly face mask on his face because he is trying to garner the sympathies of those on the jury who believe in the mask mandates and who think that that somehow protects them. He is doing everything he can to manipulate the jury and the judge and he is failing badly at it because, first of all, he's not that smart, and second of all, he has a losing case. There is an old adage in the law that says that the person who represents themselves has an idiot for a client, or I think the actual quote is, has a fool for his client. But it's the same thing. You have a fool for your client, you have an idiot, it's the same thing. The man is not functioning on all cylinders. I feel badly for him. I feel badly for anybody who has to carry the moral guilt of having run over and killed 6 people at a Christmas parade of all things. Mr. Brooks should have pled guilty. He should have thrown himself on the mercy of the court. And I believe he might have done better for himself than he did by going into court and simply annoying everybody in the way that he has. Sovereign citizens, honest to goodness, simply cannot help themselves. It's like somebody who thinks they can fly. They learn that they can't fly when they hit the ground. Mr. Brooks is going to learn that he can't fly when the jury comes back with a conviction on all counts. All he's doing is lengthening the trial. And, of course, making a great video record that he can watch in prison for years to come. So, that is sort of my take on the Darrell Brooks trial. If you have any questions, please feel free to leave them in the comments down below if you haven't already. Go over here and subscribe to our channel. Click on the notification bell so you can be notified when I release a video on this channel. Thank you so much for watching. Have a terrific day, and don't be a sovereign citizen.